So the second principle of natural justice, which we are covering, is rule against bias. As you can understand, just from a literal meaning of that, it means that the person who is in the decision making position is not biased, is taking an independent view, an objective independent view based on the facts of the case and the applicable law. I'll just read out a bit from the third bullet point. The term bias refers to a predisposition to decide for or against one party without proper regard to the true merits of the dispute. So the decision maker has to be a neutral third party. And of course, when it comes to administrative authorities who are in adjudication position, or even the first appellate authority, for instance, there is a lot of concern in the world out there of departmental or institutional bias. But let me quickly go over the first two categories of bias. Pecuniary bias and personal bias. Pecuniary bias, it means that the decision maker has some monetary benefit involved in that particular decision that is being taken. And to that extent, if there is any pecuniary interest in the subject matter of those proceedings, then the person should not be in the decision-making position. The second is personal bias. Personal bias arising from relationships. You know the person you are demanding tax from is a relative, is part of your immediate family, is a relative, or is a friend, is someone that you had crossed paths with earlier. Whatever may be the reason, in favor of, to be biased in favor of that person or to be biased against that person, both ways. If there is such a personal bias on either side of the equation, then the decision maker should not be taking the decision in that particular matter. So that's pecuniary bias, and there is personal bias. Coming to departmental or institutional bias, as I said, there is a very obvious concern that that administrative authorities are performing a whole spectrum of functions. They are part of enforcement of that law. They are part of that department of revenue who are supposed to be looking after the tax provisions. It is that person who has discovered the alleged contravention, alleged violation, and then it is that person who is also going to decide the particular matter. So there is a widespread view that the nature of quasi-judicial functions is such that while we cannot do away with them for various practical reasons, there is a concern that it is an officer of the tax department who's deciding on the show cause notice which has been issued. And I'm not the only one saying it. There is also it's also expressed in other scholarship and literature that at the show cause notice stage, it's very rare for a favorable, an order in favor of the taxpayer to be passed, which has led to these beliefs that there is some departmental or institutional bias at that level. But as I said, that's true for any administrative authority fulfilling quasi-judicial functions. It is inherent in that, but there is no ground to say that quasi-judicial functions should not be performed. It is something of a practical reality that that follows if administrative authority is given quasi-judicial functions. So departmental and institutional bias is studied in scholarship, but there is there is an acceptance that given the need for administrative authorities to perform quasi-judicial functions, this sort of human probability to have a certain belief is something that you work with and you try and instill beliefs against. So these were the three common types of biases which are documented and studied in Rule Against Bias. And this brings me to the end of a description of the principles of natural justice. Broadly, they are two: the right to fair hearing and the rule against bias. Some people put reasoned order as a third principle, but generally the belief is that reasoned order is part of the first one, right to fair hearing. Now I'll finish answering the question which I started in the beginning of the session, which was, why should you comply with principles of natural justice? The first part of the answer which I gave was from a rule of law perspective, from a justice perspective, that what does it mean to do justice, to have fairness in processes, to have reasonableness in process, dignity, equality, non-arbitrariness. So my first part of the answer as to why you should follow principles of natural justice was therefore from a due process, from a justice perspective. But I have just quickly pulled out three judgments. First one is the Supreme Court, the other two are of the High Court, given in the context of customs and GST, through which I'm trying to sort of emphasize that apart from the justice perspective, you may have a self-interest perspective in following principles of natural justice. Why do I say that? Let me quickly go over these three judgments and then tell you why I'm saying you may have a self-interest perspective to complying with principles of natural justice as well. First case is Kothari Filaments versus Commissioner of Customs. It's a 2009 ruling of the Supreme Court. Very briefly put, from our perspective, we're talking about principles of natural justice. There were some other facts also involved here, but from a principles of natural justice perspective, the key fact was that the Commissioner of Customs relied on certain documents, some evidence which was not disclosed to or shared with the person against whom the decision was taken based on that particular document. And when this was brought out in the proceedings before the Supreme Court set aside that order passed by the Commissioner of Customs on this very ground, that the relevant material on which the Commissioner took that decision, it was an important material on the basis of which decision was influenced, but that material wasn't shared with the concerned party. Of course, as you know, the Supreme Court or the High Court in such situations, when they set aside the challenged order, it's not that the issue goes away. You just have to start from scratch. It's like on a snakes and ladders game. It's like you get bitten by a snake, you have to start from zero again. So the challenge order was set aside, the matter was remitted back to the Commissioner of Customs for starting the whole thing afresh and doing it the right way. The order specifically said that if the Commissioner intends to rely upon that document, it has to be made available to the concerned person as well. So that dealt with not sharing relevant information or evidence with the taxpayer. The second case was Swastik Traders versus State of Uttar Pradesh. Here it was about goods being moved without the necessary documents and necessary disclosures being made, and the goods were confiscated, so on. There was some on-the-spot notice, and the person paid up the tax being demanded, but then filed an appeal against that order, challenging that demand of tax. The first appellate authority decided the appeal without granting a hearing to the appellant. And when this was challenged before the Allahabad High Court, the High Court set aside the order of the first appellate authority, saying that the matter has to be started afresh, following the process as should be followed. Third case, IRA Batteries versus Principal Commissioner of Department of Trade Taxes. This is from Delhi. This is the case which I was mentioning, that a show cause notice was issued saying that you issued fake invoices, but it has no mention of any invoices in the show cause notice. So this extract in the table is from the judgment of the Delhi High Court, saying that the show cause notice was bereft of the necessary particulars that did not allow the petitioner to respond to the same with any clarity. Even though the show cause notice called upon the petitioner to appear for a personal hearing, it did not specify the date, did not specify the time or the venue of such hearing. The order was set aside. So these are just three examples. I could have pulled out many more cases. These are not exceptions, unfortunately, which explains why I'm here, I guess. But what I'm trying to build towards is what I said, is a self-interest perspective to complying with principles of natural justice. If these principles are not followed, what is happening is that you are increasing the costs for yourself and your department. What do you mean by increasing costs? By costs, I mean everything. I mean time cost, energy cost, opportunity cost, and the money which is involved in fighting the matter up to the Supreme Court or the High Court, should an order get challenged on the basis of violation of principles of natural justice. You understand what I mean by time cost, opportunity cost, right? You anyways took the time to let's say, I'll take the first case in Kothari Filaments. You anyways took the time to do some investigation, to undertake some inquiry, and then issued the order. That some amount of time and energy and money was spent in it, because that thing, that evidence, that particular information wasn't shared with the taxpayer. This matter went right up to the Supreme Court. Imagine all the money and time and energy which was spent in briefing the council. Your time, you could not attend to anything else except to the extent that you have to brief the council, prepare the paper book, and so on and so forth. Fight it out before the Supreme Court, watch the Supreme Court scratch it out, and then restart the whole process. So there's valuable time which was spent first in arriving at the order which gets scratched out, and then the entire fight from the moment it gets challenged for such a obvious thing that of sharing evidence with the taxpayer. So there's valuable time which is lost of yours and of other people in the department. There are obviously money costs, and there's an opportunity cost. You could have done so much more with your time had you not been involved in this litigation, right? So in that sense, these examples and others show that your goals, individual goals as part of the department or the whole department's goals, are not served by skipping over or jumping over some of the facets of principles of natural justice. And in that sense, as I said, even though there is some flexibility, it's not that all the facets have to be complied with in a very strict singular manner. There is flexibility, but all these many facets which we just discussed come together, and your decisions and actions will be evaluated on those. And jumping over these on account of shortage of time or whatever may be the reason, is basically not furthering even the department's goals in any way. So that's what I meant, that there is a justice perspective, which is what the Chief Justice of India wrote extensively about in the judgment that I read out from, and then there is a self-interest perspective, which I just spoke about. So I can only hope that that you're able to appreciate the importance of doing these little things, which should be standard operating procedure in that sense when it comes to adjudication. Any questions? Any doubts on anything that I said?
When a taxpayer was issued with a notice, and in his reply to the notice, he is so sure of winning the case. So he has written, "We do not wish to be heard."
Okay.
Before adjudication.
Okay.
And adjudication order was passed against the assessee. Can he later claim that principles of natural justice was not followed?
See, if the person gave it in writing that we don't wish to be heard, then you have a strong case to say that it was a right which was waived by the taxpayer. And often also, even if the taxpayers don't give it in writing, it may happen that you'll give the first opportunity, nobody will turn up, second opportunity, nobody will turn up, then after some time you will pass the order. So I think if a person has given in writing, the chances that they can file an appeal and try and get benefit of setting aside this order on this ground are very slim. The courts will also look at the facts and circumstances of the case. So in the example that you mentioned, I don't believe no lawyer will advise such a taxpayer to challenge the order on this ground, can challenge on other grounds. And even if a lawyer advises this person to challenge the order, you will have the documents in place with you to be able to successfully counter that challenge.
One probably a simple question: whether this principles of natural justice is applicable only to quasi judicial authorities, or the courts can jump P&J in the interest of justice.
Who can jump?
The courts,
The
High
court,
Courts, and Supreme Court.
Oh.
Are they sacrosanct of that?
The court, see, principles of natural justice in the sense of these different facets which I just mentioned, they bind any decision maker. And in fact, they bind administrative authorities even to an extent in performing their administrative functions. So in that sense, any decision maker is bound by principles of natural justice. The judges themselves do some administrative functions in management of their own internal functions, and in that sense, even they, to the extent they are performing administrative functions, even they are bound by it. What the Supreme Court in Dharampal Satyapal was saying is that in taking a decision, the tax officers cannot jump over the requirement of meeting any principles of natural justice, but the Supreme Court, in deciding whether to set aside such an order, Supreme Court can decide whether there was a ground to jump over, say, issuance of show cause notice. So in that sense, judiciary or members of the judiciary as performers of administrative functions, which is the first scenario, either in assigning cases, master of roster, whatever, they will also be bound by principles of natural justice to the extent they apply. Judges, in their role as judges, addressing the dispute between the tax department and the taxpayer, their job is to decide, so they are not bound by principles of natural justice there. But in that sense, they have the scope to interpret whether in what degree of strictness any principle of natural justice needs to be applied. Yes.
The law says don't give more than 3 adjournments may be given.
Yes.
In that sense, I give one adjournment.
Okay.
I send one letter of, she gave me. I give one letter for first hearing. The party doesn't respond.
Okay.
Then what do I do? Adjournment means when I ask for adjournment, the question of giving no more than 3 adjournments is prescribed. What if I don't ask for an adjournment? What do I do? I have a board that says I have to give 3 first hearing. That is theoretic. I mean, I'm just asking a theoretical question. Supposing the party, and as Madam said that customs case, usually show cause notice is got and subject, but they can give either a written reply within 30 days or they can appear in person in such and such address and they can give a oral reply.
Oh.
So that is one part. Another part is I give personally in addition. He doesn't seek any adjournment, he doesn't respond at all. That means no party. So that means he is not willing to participate in the judicial process. Then what do I do?
This is similar to the question which I have just answered as well. That if the scenario is that you have given an opportunity for hearing and the person didn't turn up, right? Did I understand you right? That you had given the time, date, and venue, but the person didn't show up for that particular hearing. So, like we said, you already have some instructions, departmental instructions on it. So, in that sense, 3 chances or whatever maybe the internal instruction, you will obviously follow that. To the extent the concern is that can this taxpayer then challenge your order saying that opportunity of hearing was not given. My sense is, as I was replying earlier as well, that the chances of success for the taxpayer in such a situation would be very, very slim, almost negligible, if actually in good faith you have given a chance for hearing once, twice, thrice, whatever is your internal requirement, and the person doesn't turn up, then, as I said, there's slim to negligible chance of saying that no opportunity of hearing was given to me and trying to convince the High Court or the Supreme Court of that. So
No, my question is, Sugar, both subjects is every 3.
Yeah.
I'm ignorant, I have got to do that. That's different. But it's only says the law says no more than 3 adjournment has been given. That means when I send the first PS notice, he has to seek for adjournment. What if he has to seek adjournment? Can I proceed with the order? In that case, will I be accused of not following the rules of natural justice?
my sense is no, that shouldn't happen. If the notice has been served, let's say I'm assuming everything else is perfect. Served in the right address, there's no problem with the address and delivery and so on and so forth. Assuming everything else is perfect, and the only concern is that this person didn't respond at that time, either in writing or in person, whether that person can then go and challenge the order. I would say chances of that are slim, assuming, as I said, everything else is perfect. I'll tell you why I'm saying that. In this judgment, in IRA batteries, show cause notice was issued, person hearing opportunity was given. The person, when the matter went before Delhi High Court, the argument of the departmental officer of Delhi Trade Taxes was that this person didn't submit a reply to the show cause notice. And the court said, first look at your show cause notice. It doesn't have anything in it for anyone to respond. So that's what I'm saying. And on that basis, they set aside the order that was issued by the tax officer. So assuming that your show cause notice is perfect, is not suffering from any of these problems, and the taxpayer doesn't respond to it, then if the taxpayer challenges the order which is passed after issuance of the show cause notice, I would say chances are slim. Because in this case, the taxpayer didn't respond to show cause notice and challenged the order which was issued and won the matter before the High Court. It could happen because the show cause notice was riddled with all of these problems. So that's what I'm saying. My sense would be that if you do the perfect job of this show cause notice, so on and so forth, and the taxpayer still doesn't respond, doesn't turn up, then the chances are negligible Because as I said, what the courts are also looking for is just to see, were you fair, were you just, you did something in, you did something in good faith, and that's all the judges are looking out for. If they can observe that you did something in good faith, it, it's in your favor. There is no such antagonism between judiciary and any officers of the government. That's why it's very fact driven. But even if they spot one thing which will show that the process wasn't followed in good faith, then things start looking a bit different. So that was a good question. That's exactly what happened in this third case, and in this case, the taxpayer won. But that's because from the first step, the show cause notice was like riddled with problems.
Local officer has elaborated everything. Say 10 defects means he has elaborated all the 10 defects and what way it has been declared by the taxpayer, and in over he has arrived for your proposal. Okay, in an annexure we call it DRC 01 or in a revenue abstract, all the 10 defects have not been taken into account. Portion of it has been taken into account and that has been made as an order, no notice. In the show cause notice, the amount is very this. When coming to the order, the officer, the person, the taxpayer knows everything about that. He is aware of the notice, he has came for personal hearing, everything is okay. But in the order, he has taken into account all that has been mentioned in the notice, the defect mentioned in the notice, and arrived for a higher taxable amount.
Okay, so I just repeated. You are saying that in the show cause notice the amount was X, but in the order the amount was X plus 1.
Yes. It is an annexure, he has discussed everything, or they say 12 defects or 10 defects, everything was discussed, and why he is going to propose all these things has been discussed. But annexure, in the annexure abstract, it has not mentioned that amount, proposed amount. But in the order, it is supposed to be higher than the proposal. So, the person is going for appeal. Will it stand in the appeal? Will it be in the favor of the department or will it be in the favor of the taxpayer? Do we have to take that annexure also a part of the order, I mean notice, and what do we done? We have it is negligence of the proper officer, but when we see that show cause notice, we will be, I think the department is going to do something that is very properly arranged, but the thing is it is not mentioned in the abstract.
So I'll just quickly read out this from section 75, then I'll tell you what I think of the situation that you described. So the provision says the amount of tax, interest and penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be confirmed on the grounds other than the grounds specified in the notice. So the first part of the clause is that whatever amount is in the order cannot be more than what is in the notice. So in that sense, that is pretty clear from the statute itself. That is what my experience even before GST has been. That if there is an annexure of calculation of the tax demanded, that annexure is part of show cause notice. And the reason why, and even I think my clients have also faced a similar situation, to which our thought process always has been that if the department in the annexure had calculated, let's say, 100 rupees worth of tax short paid, then my client would have framed an answer to respond to that 100 rupees. If the department had calculated 150, then I would have done something beyond that. So in that sense, if the annexure amount is less for any reason, maybe some invoice was left out, some rate was differently applied, and the order is different, then it just lends to the belief that the taxpayer didn't have adequate opportunity to respond to whatever is it that the departmental officer is thinking. So I think that's a situation where, to the extent of that excess amount in the order, there could be an issue.
Here The second part is no demand shall be confirmed on grounds other than the grounds specified in the notice. The notice every ground has been disclosed. In this case, the department will be the user, no? If we go for
Yes, if the amount in the notice is less than the amount in the order, then that's a problem per se. That's what section 75 says. Of course, it depends why there was a difference in the two amounts. If, let's say, the difference in the two amounts was because certain invoices were not captured in the annexure. Let's say annexure picked up 10 invoices, not 12, then it's a problem. Because then if you had captured 12 invoices in your calculation, then the taxpayer would also have defended 12 invoices.
I have another one. We have to reply. The taxpayer has to reply for the show cause notice.
Okay.
And before passing an order, he has to be called for personal hearing. That is the thing we are doing it.
Okay.
In this Delhi court you have mentioned, no show cause notice has been, no reply has been made in the show cause notice. And getting the reply only they will be asked for personal hearing. Sure, date and time of personal hearing has not been mentioned and it has been not even remanded. It is on the favor of the taxpayer, it has been set aside, isn't that?
Yes.
After getting, we were taught in the way that show cause notice has been issued and notice has been, reply has to be received.
Okay.
Getting the reply before passing the order, the taxpayer has to be given 3 opportunities
Yes.
for the order.
Yes.
That the main thing is not done by the taxpayer.
Yes.
And how what is done is again on the favor of the taxpayer and against the department. It is a question to be raised, no?
See, we have only the Delhi High Court judgment to read. We don't have the actual show cause notice. What you'll see when you read this judgment is that the High Court is observing that the show cause notice, you are right, on the process. That is what even I have
It is
experienced.
online. There is no need of for a reply. The taxpayer need not know the time, venue and everything is not needed.
Yes.
He can reply the same for online.
Yes.
Online. He can reply online. Getting the reply, it is in our part. The wrong is in our part. If we made an order without getting without providing his personal hearing.
Yes.
Your reply is not received.
Yes, but in the show cause notice itself, for some reason, we don't know why the officer did that. For some reason, in the show cause notice itself, it was written that you are being given opportunity for personal hearing, but didn't write. You are right on the practice. That is what my experience from the other side also has been. That this is what happens. You submit a reply, then you get one letter saying that your personal hearing is scheduled. I don't know why the tax officer in the show cause notice only said something, but didn't complete the whole thing. Okay, so thank you. I hope it was useful to know something more. Thank you.